Hi everyone, welcome to Impact Academy. I am Yashasvi Chintada. So today, let us see in polity each topic. Let us quickly review. Okay, so that before answering questions, if we can quickly look at what is the crux of the issue, rather than going through Lakshmikant polity or something in depth. So if we can see briefly, then we can start answering the questions. So if you are a beginner, it's better to go and read a textbook. Okay, Lakshmikant polity or anything. So but if you're already been preparing for some time, then this what is a brief or summary should be more than enough. So let us quickly look at procedure for amending the constitution. It's okay. So Article 368 is the one which deals with the procedure for amending the constitution. Okay. So the alteration of certain provisions of the constitution are not considered amendment by the constitution of the constitution. Such provisions can be altered by parliament by a simple majority. Okay, so not every amendment to the constitution. So if the constitution is slightly amended, it need not necessarily be under Article 368. Okay, there are several provisions which can be simply altered by simple majority also. Okay, simple majority also you can alter. Not everything comes under Article 368. So other provisions of the constitution can be changed only by the process of amendment prescribed in Article 368. Okay, so in the case of provisions which affect the federal structure, a ratification by the legislature of at least half of the states is required. So especially that which affects the federal stature, okay, federal structure. So for example, if you are talking about GST, okay, any such bill, it needs to go to this ratification of legislatures of at least half of the states. So current right now we have 28, right? So after Telangana we had 29. Now that Jammu and Kashmir is no longer a state, we have 28. So more than half. Okay, so more than 14. Okay, at least 14, at least half of the states. So if there are any provisions which affect the federal state structure, then a ratification by legislatures of at least half of the states is required, and before the bill is presented to the president for his assent. Okay, such provisions are the manner of election of the president. Okay, Article 54, 55, extent of the executive power of the union and the states, the Supreme Court, high courts. Okay, and we are talking about Article 241, etc. So we are doing this from the point of view of exam. Okay, so this is not exactly for a beginner. This is for someone who is already a little bit experienced. Okay, so before answering the questions, we are quickly going through the content so that we'll be able to answer the questions better. So we'll be looking at solely from the exam point of view. So all these things are very important. Manner of election of president, okay, and executive power of union and states, Supreme Court, High Court, distribution of legislative power between union and the states, which comes under chapter 1 of part 11. So distribution of legislative powers between union and the states. So obviously it's affecting the federal structure. So any of the lists in the 7th schedule, representation of the states in parliament, okay, representation of the states in parliament, article 80, 81 and 4th schedule, and provisions of article 368 itself. So these are the things, okay, which will come under article 368. So apart from this, other small things like changing the boundaries of states, or changing, making one state into two, or merging two states, okay, those things will not come under article 368. So that is very important from exam point of view. There is no separate constituent body provided for by our constitution for the amending process. So there is no separate body. In other countries, in order to amend the constitution, you have a separate constituent body, but India there is nothing like that. An amendment of the constitution can be initiated only by the introduction of a bill for the purpose in either house of parliament. So this is frequently asked in question. So if you want to do an amendment to the constitution, it can be initiated only in either house of parliament. That means both Lok Sabha and Rajya Sabha. So usually questions are asked, if it is a constitution amendment bill, it can be introduced only in the Lok Sabha, okay, or they can say only by elected members of the parliament and the assembly. Some questions will be asked like that. No, okay, only in either house of parliament. That means it can be done either in Lok Sabha or Rajya Sabha. And the amendment bill should be passed by each house by a special majority, that is more than 50% of the total membership of the house, and by a majority of not less than 2/3 of the members of that house present in voting. Okay, so this is what is called a special majority, right? Simple majority is simple majority. If there are 100 people in the house, 51 is simple majority. But what is special majority is 50% of the total membership of the house. Okay, if the membership is 545, it need not mean that everyone is in the house. There might be so many people who are on leave or who are not attending. So 50% of the membership of the house, that is one thing, and also majority of not less than two-thirds of the members of the house present in voting. So on that day, if there are suppose 300, so two-thirds of the members, so 2 by 3 of 300, that is minimum 200 people have to vote for it. Okay, that is called special majority. Okay, so amendment can be done by simple majority, special majority, or ratification of half of the states. So these are three ways. Constitution stands amended in accordance with the terms of the amendment bill after the president's assent is accorded to it. So the president gives his assent. Okay, next, the blend of rigidity and flexibility in the procedure for amendment. So the procedure for amendment is rigid insofar as it requires a special majority and a special procedure. There is no separate body for amending the constitution as exists in some other countries. Okay, so remember this point. It is frequently asked in questions. The state legislatures cannot initiate any bill. This is very important. The state legislature cannot initiate any bill for amendment of the constitution. Only the Lok Sabha and the Rajya Sabha. So subject to the provisions of Article 368, constitution amendment bills are to be passed by the parliament in the same way as ordinary bills. So just like how ordinary bills are passed, constitutional amendment bills are also passed under Article 368. The procedure for joint session is not applicable. This is again very important. There is no procedure for joint session, and state legislatures cannot initiate. These two are very important. The previous sanction of the president is not required. Again, very important. This is where if you're not clear with the basics, you will get confused in the when you're answering the question. Okay, so all these are very important. State legislature cannot initiate the bill. Okay, procedure for joint session is not there. Previous sanction of the president is not required for introducing any bill for amendment of the constitution. The requirement relating to ratification by which the state legislatures is more liberal than the corresponding provisions in the American Constitution. The latter requires ratification by 3/4 of the states. So in America, you need 3/4, but here you need half. So the amendment of Article 368 in 1971 has made it obligatory for the president to give his assent to a bill for amendment of constitution. So once it passes through both the houses, it is obligatory for the president to give his assent. The president cannot deny. Okay, when it is presented to him after passage by the legislature, and this is with reference to 24th Amendment of 1970. So this 24th Amendment Act is also very important. Okay, this is like it was during that period. So if you look at the basic structure concept, so first we have the Minerva Mills, and then we have the Golaknath case. So in the Minerva Mills, the Supreme Court said the constitution, I mean the parliament has power to amend everything. In Golaknath case, the Supreme Court said that the parliament does not have the power to amend the fundamental rights. Okay, that is where the issue started, right? So then the parliament came up with this 24th amendment as a what you say as a challenge. Okay, so because the Supreme Court said you cannot amend, parliament came with 24th Amendment Act saying that no, we can amend. Okay, so there is always this fight going on between parliament and the Supreme Courts. Anyway, so remember all these things. 1971, and then 1973 you have the famous Keshwan and the Bharti case. So all these are very important points which we have seen now. Previous sanction of president is not required. State legislature cannot do anything, only parliament, and it is like ordinary bills. There is no joint session. So whether fundamental rights are amendable. Until the case of Golaknath, Supreme Court held that no part of our constitution was unamendable. That means in the Minerva Mills case, okay, Minerva Mills is the first case, right? So in the Minerva Mills, which is in 1960, I guess 1960. So Supreme Court said everything can be amended. But in Golaknath 1967, they said you cannot. What is this? And held that if any such rights is to be amended, new constituent assembly must be convened for making a constitution or radically changing it. Okay. So basically, they are saying that simply with the normal Article 368, you cannot amend this what is fundamental rights and all these things. So 6 judges in a special bench of 11 overruled the previous decision, which is this Minerva Mills, and held that any of such rights is to be amended. So the fundamental rights, then a new constituent assembly must be convened. So as a challenge, the government came up with the 24th Amendment Act of 1971. That's why it's very important. It held that amendment of the Constitution passed in accordance with Article 368 will not be law within the meaning of Article 13, and the validity of a Constitution Amendment Act shall not be questioned. Article 13 is fundamental rights on the ground that it takes away or affects the fundamental right with reference to Article 368. So basically, in 24th Amendment Act, they are saying that no, we can amend under Article 368 and it does not come in clash with Article 13 or anything. So we can amend the fundamental rights also. Validity of the 24th Constitutional Amendment Act itself was challenged in the case of Keshwananda Bharati in 1973. So, but this time the Supreme Court agreed with it. Okay, in the case of Keshwananda Bharati case, the Supreme Court overruled its own decision given in the case of Golaknov and held the Parliament could not amend any provision of the Constitution, including fundamental rights, in accordance. Okay, could amend. Okay, Parliament could amend. So in the Keshwananda Bharati case, the Supreme Court agreed that it can amend. Parliament can amend the fundamental right also. Only in the Golaknath case, it did not allow. Okay, before that, Minerva Mills also it was fine. After that, Keshwananda Bharati it was fine. And when was the doctrine of basic structure of the Constitution? Okay, the basic structure of the Constitution was introduced with the Keshwananda Bharati case. Okay, we'll look into that in another session. So before answering questions on amendment of the Constitution, just go through these things. Okay, all these are very important. Previous sanction of president is not required. State legislature cannot do anything, and it is only in the Parliament. So even a private member of the Parliament can initiate a bill, and it will be treated like an ordinary bill. There is no procedure for joint session. Okay, and this the 24th Amendment Act. All these things are very important. Okay, so that is about the procedure for amending the Constitution.